everyone. Welcome back to Open Line. So glad you are with us tonight on a Tuesday night. It's August 10th. We're talking about elder law, a chance for you to call in and get some advice, really on estate planning. That's what elder law is all about. Happy to have with us Chris Johnson, elder law attorney with Takacs McGinnis in Hendersonville, joining us via Zoom from his office there. And I want to start this segment with just what would you say are the foundational elements of a good estate plan? You're walking in, you want to have a good estate plan. What are the things that you recommend be done?
That's a great question, Ben. The most important things I always start with are the powers of attorney. And the reason I emphasize powers of attorney is those are documents that are going to take care of you while you are living. The idea is you have a durable general power of attorney and a healthcare power of attorney. And what that does is those documents convey legal decision-making to another person if you're unable to do so. So if I gave you power of attorney over myself, Ben, let's say I made you my healthcare power of attorney, if I could not make medical decisions on my own behalf, then you would be able to step in those shoes, talk to my doctors, and make those decisions for me. And of course, you and I, if I'm going to give that job to someone, we're going to have some conversations, and I'm going to tell you what my values are, share with you the things I would be willing to go through, things I wouldn't be willing to go through, and make sure that that decision-making authority is there. And then the durable general power of attorney, that takes care of legal and financial decision making. And so the analogy I use that I think most people in our technological world can grasp real easy is when I turn 18 years old, when we all turn 18, we're imbued with certain legal rights. We can own property, we can open a bank account, we can buy and sell homes, we can hire people, we can fire people. We have all these legal rights that we can do. And what you're doing is you're highlighting them as if you were in a Word document or on email. You're highlighting all of those rights, and you're hitting right click on the mouse, and you're hitting copy, and then you're pasting them on another individual. A common misconception is that when you do this, that somehow you have given this person legal authority over you, that they are in control of you. So if I made you my durable general power of attorney, it doesn't make you the boss of me. In fact, very much the opposite. You would have what we call a fiduciary obligation to only do what's in my best interest. But it allows you to make decisions on my behalf if I'm unable to do so. And so we take care of the healthcare decision making, we take care of the legal financial decision making. Should you become incapacitated, or in this scenario, should I become, someone is there to make those decisions for me. If you don't do that, you're forced at getting a conservatorship, and that's where you file a petition, and basically what you're asking the court to do is that you're asking the court, just like in my analogy, to take those legal rights, highlight them on that individual, except instead of right-clicking and hitting copy and paste, you're right-clicking and hitting cut and paste, and you're literally stripping that individual of their decision-making authority, and you are giving it to another person. It's very expensive when you go the court route. It's also very invasive, and so if you have power of attorneys, most often you can sidestep that scenario. So you have those two documents that take care of those issues, and then if you're just going with a very simple plan, you can have something as simple as a will that lays out who you want to be in charge of your estate and how you want it to go. If you want to get a little more complex and avoid probate, you can set up something called a revocable living trust, which is effectively a will substitute. And instead of having to go to probate, if you have your assets designated to that trust or titled in the name of that trust, now you don't have to go through the probate process, because when you pass away, that revocable living trust has legal control and authority over your assets, and it'll take care of paying any lawful debts and then making distributions in the manner that you've laid out. And so those four documents, healthcare power of attorney, durable general power of attorney, a will, and then possibly a revocable living trust, I call those the four foundational elements, four foundational documents of any good estate plan.
I like that, the four foundational elements. And I mean, everyone hears, okay, you need to get the medical power of attorney. It's tough. That's a tough conversation, not only for an individual to have, but to convey on someone else. I mean, it's a big thing for someone else to take that on. But you're saying it's the right, yeah, it's a huge thing, but it's the right thing to do. It's really a gift that you are giving to your family in a way, right? I mean, if it does get to that point, you want, there needs to be a clear path as opposed to chaos. Is that right?
That's exactly right. And the clear path, the phrase I use is there needs to be a plan. If you hand over that chaos, that's what you are going to get is chaos. Chaos in, chaos out. When you hand them a plan, the way you put it, Ben, couldn't be put any better. You're giving them a gift. Because when you set up the healthcare power of attorney and you have those decisions and you have those conversations about what decisions you want, now your child isn't going to be guessing what your wishes are. They're going to know what your wishes are, which means they're not going to be saddled with regret. They're not going to be saddled with being unsure whether or not they made the right decision or not. And those are very difficult things. I've had very powerful conversations with just multiple clients talking about how they agonize over the decision making because they didn't have that input. And so when you give someone a plan like that, you truly are giving them a gift. It is a job. When you serve as someone's power of attorney, I joke, it's not a title, it's not some honorarium. You don't go bragging, I'm so-and-so's power of attorney. It's work. When you serve as a personal representative in a will, it's work. If you serve as a trustee, it's work. But it's work where you're taking care of your family members, and I don't think there's better work in this world.
Wow. Okay, that's very good. And then I think people are reluctant to do the power of attorney. So we talk about healthcare power of attorney and the gift that is. The other that you talked about, just the power of attorney over your finances and that kind of thing. I like the way you describe that. People are worried, I feel like, that means suddenly they lose all control. And the way you're saying it of copy and paste as opposed to cut, that's you're still a person in this scenario, right? You don't lose all control.
No, you're more than a co-person. While you have capacity, you are still the person in charge. That person that you've provided that power of attorney authority, they're like a co-pilot for you. When you maybe you're out of the country and need something done here, they can help you out. They cannot overrule you. They cannot tell you, well, I'm going to do this because it's better. If you still have all your faculties and still have your capacity, you are in charge of your life. I joke when I have families in there, when we sign power of attorney with the children, I say, now, Mom, Dad, you're still the boss in this room. You guys have not given that up. And some people like to hear that because I think there is this misconception that if I give someone power of attorney, I'm truly giving them authority over me. All you are doing is making sure they can act when you cannot.
Well, and Chris, I mean, I feel like we've seen the movies where you give someone power of attorney and then they stick them in an insane asylum, right? I mean, that's kind of the nightmare scenario. And I don't know if that comes up in your meetings, but I mean, I think that is the nightmare scenario. And so how do you overcome that?
That's right. There was that recent movie. I'm not even going to mention the title in Netflix. I think it was Where It Was, and it scared a lot of people. And it was in the scenario in the movie was that they were getting conservatorship over people, and then yes, locking them away in facilities and draining their tanks. There are lots and lots of legal safeguards. Again, no system run by people is ever perfect. But the legal safeguards that we have by having the judicial oversight and scrutiny, having these judges review all the decision making, review the expenses made, there are annual reports to the court that have to be made. It is very difficult to do stuff like that. Obviously, Hollywood likes to, dramatize these issues a little bit, and certainly it makes for good television and good theater, but it just gets a little far afield of the way the facts really are. We did have a case in Middle Tennessee not too long ago, I'd say a few years ago now, where a conservator was basically abusing the ward they were over. And although you never like to see it, if you could have a happy ending in that scenario, the ending is that individual ended up in jail for a significant amount of time. And in this case, that happened. And so the system did work and correct that issue that arose. So people do try it from time to time, but they get caught.
Very good. All right, I like that. I like that whole discussion there. That's foundational sort of elements of good estate planning. All right, we're going to take a break. We'll come back, continue our discussion. If you want to call in with a question about your individual situation, that's always good, and it helps a lot of people, I'm sure, when they hear your situation. There's the number, 615-737-PLUS, 888-7587. Take a break. Be back right after this.